Hi, my name's Troy Agate. I'm just doing a new Defend Yourself in Court in a criminal matter, and things you need to be aware of and how to process all the information you're about to get. My case was ISS Security Pty Ltd, part of the multinational ISS world, based over the entire world with 400,000 businesses and 600,000 employees. They've got money, they've got a lot of money, and me, I had nothing. I'd been out of work for 2 years with the Australian Federal Police. They refused to allow me to get any other work, so I was in a pretty hard place, and I pushed ISS, and I continued to push them until they served me for a court subpoena to be heard in the Australian Supreme Court. And from that point, I'm going to tell you what you're really in for when you're self-representing yourself, and I'm going to be using ISS Security Pty Ltd versus Troy Agate as the example case, and so you're aware of the outcome of that case. I actually won the case, and the only order was made for my protection, and that was, as stated by the judge, was that I couldn't publish any contracts, in which case I had no interest to publish their contracts anyway. We'll get more into detail with that a bit later, but for now, we'll get started on what it is that you're going to be facing when you take on a company as big as ISS Security, and the amount of money that they've got to throw at a case, and see where it wound up in court. For a little background on this video, I'd like to let you know why I'm going to make it. I've been looking online for self-represented defendants in court, and I don't see too many of them. I see a lot of self-litigation, but no self-represented litigants. I did find a couple, and in all of those, they pretty much tell you, run away as fast as you can. But for me, I think I would rather have the reputation and the dignity to walk away and hold my head high and challenge what's wrong and what's illegal for someone challenging me for a matter that they provoked, they started, I finished. So with that knowledge, we'll get started on what you're going to be presented with. First off, you'll know the applicant, which will be, in this case, ISS Security. They will throw a lot of money into making you look guilty. I was working with the Australian Federal Police at the time, and they made allegation after allegation after allegation, and that wound up in a police investigation, federal police investigation, for about 19 months, at which point I was found clear. They had written to everybody, even though they denied writing to anybody, but they had written to everybody and phoned everybody and complained because the police weren't investigating quick enough, and they were just after my job. They didn't get it the way they wanted, but I did surrender my job for the sole purpose of going after ISS Security in the public realm and bringing out the rubbish that they were conducting against me. And I did that, and I held my head high, and I pushed them until they took me to court, which they made the mistake of doing, which allowed me to air my case in the Supreme Court and put my case forward in front of a judge and win. Many people will tell you that the court system is a jagged system. It's rigged for the lawyers and judges. I don't believe that for a second. I think that the court system is ultimately pretty fair. I know there are some terrible cases out there where people have lost even though they were right, normally because they didn't get the evidence they required to prove the case prior to going. Me, on the other hand, I pursued the information I required by writing indiscriminate letters constantly to ISS Security, and when they stopped responding, I would change my tack. I would then start asking, where do you keep your contracts? They would then panic and threaten to sue me, which really wasn't an interest because it wasn't a contract I was after. I was after acknowledgement of the letter. And I got that when they threatened to sue me, so they can't say they weren't advised of what I was asking and what I was doing. Originally I was writing to ISS Security management right up to CEO of Australia, Charles Winkworth. He's no longer employed. He's left owing $3.5 million for another scandal case that he's now involved in. But the realism of it is that if you don't manipulate the system to get the evidence that you require to prove your case, then on all likelihoods they'll have the evidence and you won't, at which point you will lose. So as much of these videos tell you do not communicate with the opposition when you're self-representing, I communicated with them every week by letters, and I wrote as many letters as I could, and I wrote them mostly in hand or by email, and I sent them out as often as I could. And because I was on stress leave from the Australian Federal Police, I had all the time in the world, which you're going to have to do. You're going to have to make time. It's going to have to be mind-blowingly time-taking and hours on end of research. Research anything that's happened in the employer's past, whether the company is yours or someone else's. Look for any charges that have been placed against that company. Look for any litigations against that company, and dig up any dirt you can find on the company, and keep that aside, because when it goes to court, as ISS displayed, they said straight to the judge, we'd never been charged for anything in Australia, and that was wrong. They were charged for using unlicensed security guards in Darwin. So it just takes every little manipulation. They said the manager wasn't on leave, wasn't sacked or quitting. He was on leave, and technically he might have been on leave, but his job was also up for grabs on seek.com, and I actually applied for that job. I thought, if you're not going to do the job right, hire someone who knows how to do it properly, and I'll do it. But of course, they refused that job application on the grounds that I was in conflict with the business, and it probably wouldn't have been a wise move. However, had they taken me up on the job offer, they would have shut me up, because I would have had to sign a secrecy document in relation to their employer. So their mistake. I did offer them the white flag, but they didn't take it, and silly boys. But yes, there is certain court language you've got to understand, and yes, there are certain documents you need to apply, and yes, there are certain timeframes in which you need to respond. Usually it's about 2 weeks. I was given 4 days. I was served on a Thursday to appear on Tuesday morning. I saw a lawyer on the Friday, wrote the documents up on Saturday and Sunday. I had them stamped by JP on Monday, and then I represented myself on the Tuesday. There's talk online where they talk about everyone will pretty much abuse you through this process, and they're absolutely right. I turned up at the courthouse, got abused for late filing of my documents, even though it wasn't. It was actually as quick as possible, in the shortest time possible. And then I got chipped 3 times by the judge for not paying attention, and rocking on my chair and looking at the roof and spinning around in circles, because I just was bored. 6 hours of listening to her slander me and defame me in front of a judge was just beyond me. But it seemed to be enough to get the judge's attention to allow me to talk, because I knew what they were saying was just rubbish. And in the entire 6 hours they spoke, they never once mentioned what my job was and why they were attacking me. So bear with me, and we'll get down to some more court issues that you need to be aware of. There is a certain mannerism you're supposed to go into court with. You're supposed to be someone who appears confident. Try to come across likeable. Don't be an attitude. Don't be, fighting with the other side while they're talking. Just write your notes down. You'll get your chance. And then when you get your chance, go through your notes and front them first before you start talking about your case. You just politely say, look, I just want to address these issues before I start my claims. These are the issues that they brought up that they're fabricating or lying about. And these are the reasons why they're fabricating or lying. I'm going to show the evidence to back it up. That's why it's important to dig up as much mud on these companies that you can prior to turning up to court. Now, in relation to the language used in a courtroom, there's actually no handbook for you as a civilian to represent yourself in court. And most lawyers or anybody who you talk to will just remind you to run away as quickly as you possibly can and that it's an unwinnable case. This is actually false. It's not an unwinnable case. Like I said in the past, you just got to do your homework and dig up the mud. Get your facts and get your evidence to support those facts. And they must be typed out and must be put into the court and filed with JP signature. JP sign all your documents, every last one of them, individually. File them as evidence individually. In my court case, ISS filed 10 pages as one evidence and the judge was not happy. So file them as individually. It takes time. It's a pain in the butt, but it pays off in the long term. So any evidence you dig up on the actual company itself, you keep in your own file. You keep that as your own evidence because that's going to refute any claim that they make to the court, which will usually be something that is not true or ballooned out to make it appear that it's something that it's not. So when you hear those things, that's when you write a note and put your evidence beside it and present it to the judge, just to show that the other side is not playing by the book. Before you get to appear in court, you'll go in and wait for your turn. Their lawyer will probably, in my case, Adam Walker from Melbourne, media guru, litigator, came inside and spoke to me like I was a child and told me to get outside. So I went outside with him, and you don't have to abide by that. You can tell him to get bent and sit there and wait for your turn. But I wanted to humour the guy. I wanted to hear what he had to say. He basically told me I was going to forfeit all my information, comply with anything that ISS required, or I won't see the light of day for 15 years, and that this is his house and he will bury me so far under the dirt I'll be breathing air from China. So you just got to go through that. Basically tell him that, it's probably going to damage your case if you do what he says, and he basically said to me, I don't give a fuck about your case. So at the end of the day, I just said thank you, Dad, and walked back inside. But then they'll call for what they call a short trial. That's where you plead guilty. And again, their lawyer will stand up and tell the judge that that's exactly what you did. You pleaded guilty and you're going to comply with any and all regulations that apply to them from the courts. That's at which point the judge will tell them that maybe I should see a lawyer and make sure I know what I'm signing before we go forward. I then presented my hand to the judge and he asked me what I needed to say, and I said, well, I didn't have that conversation with him, but that was just a bully tactic. As it was outside was a bully tactic. They tried again inside the court for a short trial. When the judge found that out, he just advised him, you must have had a conversation with someone else. And then from there we proceeded to a long trial. Long trial proceeded with 6 hours of them defaming and slandering me in every manner of perspective, and I didn't pay much attention to any of it because I had the evidence to back up the truth. And the judge did pull me up a few times for not paying attention, and it was the third time that he stood me up and advised me I could be doing time in jail for all this. And that's when I politely advised him that all my documents were stamped freedom of information, and it was actually a constitutional court issue, not a Supreme Court issue. So it was only after that point that the judge had any interest to hear what I had to say. Then I put my case forward, and at the end of the day we had a recess. The judge read my documents and found in my favour. So there is they like to use a lot of big words, paraphrasing, referral to other documents that you won't have possession of. You can request to see those documents if they present them as evidence to a court, and all you have to do sometimes is ask for it. Sometimes they'll be presented to you by the other side and they'll just be handed to you as evidence, and then you get to challenge that evidence at the point when you get to talk. When you're representing yourself in court, you've got to present yourself like you're actually a part of the court system itself. So you got to show up with, a nice suit on and show everyone respect and courtesy. However, when it comes to the people challenging you, you can bet that someone's not going to be nice to you. They're going to try and bully you. But don't bite into the fact that they want an argument out of you, because they're going to try and get information out of you to try and squash your case before you get through the front door. So bite your tongue, save it for the judge, and wait for your turn to stand up. And then when you stand up and smash them with a sledgehammer. And don't be light on them. Don't be delicate with them. Don't feel sorry for them. If they've brought you to this point to challenge you, there is only one way out, and that is to demolish them. Take a big hammer to their tall building and smash the foundations until it topples. Don't stop until it does. Everything you do is about bringing them down to their knees. Once they're down to their knees, you've got them. Finish them off. Do not play with them. Don't sit there and provoke them. Don't give them any chance of opportunity to refute what you're saying. Back it up with the evidence. Don't guess on anything. Don't surmise on anything. Don't gamble with any, lucky shots. Just use what you got as evidence. 100% fact. And you'll get through this. It's going to be stressful. You're going to put a lot of time in it. So don't waste your minutes when you get into that courtroom. Use it to the full extent, and you take every fact and issue to challenge. And anything that they present against you, if it's not true, you make sure it's heard. A lot of the times before you go into a courtroom, they will try and compromise and force a settlement. Usually if you're the defendant, it's going to be the other side who's going to offer you something that is way not in your favour. If you haven't got evidence enough to support your case, it is worthy to look at what they're offering you. But when you're 100% correct, and you 100% got the evidence, and you 100% know what you're talking about, don't take it. That's what I did. I challenged it, I stood for it, and I won. So it all depends on your individual cases, and you need to weigh up your values, because sometimes family is probably more important than your litigation case. But just be aware that for some of the stuff you're being taken to court for, you can be doing time for, and it's going to be costly whatever you do, because you're going to have to pay their legal fees, whatever the judge decides that figure's going to be, or you may have to spend some time in jail for any breaches of law that you conducted to wind up in this position. So be aware that you can negotiate these terms, and you can say, well, yes, I'll agree to that, but I'm not agreeing to this, and you may or may not get a bargain deal. But if you don't, then take it to the court and challenge it in the court. It's better to have a judge look over your case and make a final decision than it is for you to gamble a thought of what you might or might not have got had you presented yourself earlier. In most court cases, it helps if you do challenge, try and look at other dispute resolution processes like mediation or consultations, or some sort of intermediary discussions. I put those offers forward to ISS. They didn't take me up on them. They said they did in the court documents, but they never did. In fact, they finally did the day or 2 days before they served me to appear in court. So they clearly had no intention of having a mediation, because the court date came before the mediation date. So, they said I didn't respond, but I checked every day and there was no email there. And the day it came, I agreed to go, and they said that they weren't going to acknowledge any fault, but within 2 days I was served to appear in court within 4 days' time. So you've got to be ready for the games they're going to play. And when you're served, don't look at the sheriff and crack up and yell at him for being served. Just thank him nicely for doing a great job, and thank you for your chance to represent yourself in a courtroom. So just keep that in mind when you start on this process. It's going to be stressful. Don't fight with your family over this. Don't fight with your friends over this. Once the court case has been challenged and set, you don't even need to talk to them anymore. You'll have all your evidence by this time. Do your homework first, connect the hooks, connect the belts of everyone above them, and bring the whole business down to its knees, one at a time. When it comes to hiring a lawyer, my case, I went to see a lawyer on the Friday. It went from $2,000 to $10,000 on the startup, and like they said, that's only the beginning costs. There's going to be more costs to come. If I was actually to take a lawyer through this case, it would have cost me probably $100,000, gone on for another 5 years instead of just one day in court, because lawyers tend to want to drag things out because they need to get paid, and that's all they're interested in. The interest is not you. If they save you, then well and good, you can thank them and you'll pay your bill. If they don't save you, you won't thank them and you'll still have to pay your bill. It's it's one of those things where lawyers just interested to drive their nice Mercedes and have their nice latte dinners and whatever else they want to do. But at the end of the day, you are just meat in their pocket, and they're just going to milk every cent you've got, and they'll ask you to beg, borrow, and steal to get it. But you need to pay them. So that's why I decided to go on my own. I wasn't going to pay $10,000 for something that I'd done all the work on. I knew the case back to front. They didn't. So anything that ISS threw up, I would know was truth or lie. I knew about every conversation. I had it all documented. I had a great diary. So I was more in a position to fight my case than it was to hire a lawyer and have them flag it out on me because they don't know the situation. When you're getting taken to court and you're the defendant, the applicant must serve you, in most cases, in person. So they can use either a court sheriff or police officer or a debt collector, but they will serve you something in person in an envelope, and the gentleman or lady will walk up to you and say, "Are you Troy Agate?" You go, "Yes, you've been served." And sometimes, lucky for me, they will serve you evidence that they have against you in that file, which is the case what happened with ISS Security Pty Ltd. They served me the evidence to the case that they were using in a nice little folded book. They then sent a debt collector around several hours later to try and retrieve that book. At no point do you have to give back anything that has been given to you during that serving process. What's been given to you in the serve, you get to keep. You are under no obligation to return anything they accidentally put in that envelope when they served you. So keep that in mind, because in my case it was a gold mine of evidence, and evidence that I could use against them. Little did they know, but it was actually more favourable for me than it was for them. So just be aware to keep that stuff and not return anything. Once you've been served your documents, at the bottom of the very small writing, and I mean it's tiny, at the bottom of the documents, it will tell you what documents to reply to. So you'll have their application and notice of you to appear in court. At the bottom of the application, it will tell you to serve a notice of defence. So you have to write up your notice of defence. And then at the bottom of the notice of defence, you'll notice little tiny writing, and it'll say counterclaim. So you apply a counterclaim. It must have a monetary value. Courts always operate on monetary value, so you need to put a monetary value of your losses. From there, you supply your notice of defence, which is just a two-page thing saying you're going to defend yourself. Then you file your defence and you file your counterclaim. Be sure to put all three in, because I didn't pursue my counterclaim, because it was just a lot of work to do. It'd be a lot more time. It's going to be dragged on for years to come, and I'd been affected enough already. So you don't have to follow it up, but at least file it in case someone else may hear your case and go, "You know what, we'll take your case on pro bono." So file it anyway, just in case someone else picks it up. But in my recommendation, if you're not going to chase it up at the end, just file it. You never know what might come the next day. So as long as you've filed it, if they then pursue the case and try and go you again, you can then activate your counterclaim in relation to that case. It doesn't matter how many years fall past, if ISS ever decided to come after me for doing these videos and making them look like idiots, then that's fine. I'll just reactivate the counterclaim and copy and paste it, and I'll put the counterclaim straight back in. It just opens up a window for further litigation on my behalf, but this time I would go them for the damages they created, now that it's been already proven that they were maliciously making statements in the first place that had me under an investigation for 19 months for nothing. Just so you're aware, the outcome of that 19-month investigation, I was found innocent. The AFP made a deal with ISS that they were getting a $10,000 contract in Canberra, which they were presented with, and I was given a charge of for further investigation of abusive language, and that language was the term Australian Federal Police. So I wasn't a part of that agreement, and I told them, the AFP, they can stick that agreement up their ring, because by this time I was in financial hardship, and I thought, I'm not just going to wear this and then go back to work like we're all la-di-da friends again. And I didn't trust my employer after that anyway, because now I know that they were paying off ISS for conducting themselves of obstruction and hindrance of a Commonwealth official for no reason other than to continue the activities that they were carrying on with. So we'll get back onto documents and litigation. Once you've supplied your counterclaim and put it to the courts, the applicant has a right to respond to that counterclaim. Lucky for me, there was no time for them to respond to my counterclaim. They didn't even get a chance to read it because I didn't supply them with a copy. The copy wasn't supplied because I only had it signed by JP on the Monday, and I was representing myself in court on the Tuesday, so I could have express posted it, but I'd rather just let them think that I'm just some idiot who didn't get any documents into the court. So that's where I left it. I went to court, and even once they were in court and they were objecting to everything I was saying, it wasn't until the judge said, "You do know he got his documents in, don't you?" And their mouths just dropped in awe over how the hell did I do that. So they had no idea, and that was the best coat hanger I've ever given someone in my lifetime, and the smile on my face was priceless. Their mouths just dropped. They literally dropped open like they were catching flies. So I nailed them twice in the courtroom to the point where they hung their heads in shame on the second occasion, but I'm sure we'll get to that later in the video. Now, if you ever are served, or you do serve your counterclaim, you got to be aware that you need to respond to that. There needs to be a response. You can't just put it aside and turn up to court, because they will get a default judgment against you without even you stepping a foot in the courtroom. It'll be done before you even turn up on the day. So the important thing is that when one of these documents are issued to you, that you do absolutely everything in your power to get that form back into that courtroom by the due date. Failing to do so, if you're running out of time, and because they've given you 4 days return when they should have given you 2 weeks, you can file an adjournment to the court, which you may have to turn up to on the court date and just say, well, listen, they've given me 4 days, I'm supposed to have 2 weeks, so and the court will most graciously grant you an extension of maybe a couple of days or something. So just be aware, and there will be some orders put against you to keep you quiet in the process of the court hearing. So you do bite yourself in the tongue, so I'd put the hours in and get the document done and in on time, and that way that you won't have any judgments against you that can come up against you later when people are saying, oh, you had a judgment against you. Yeah, but it was only because, so in my case, the judgment is that I can't publish contracts, so people look at that hearing and go, oh, you lost. Well, in fact, I didn't lose, and I've got the transcript to prove it. I was actually told that it was for my protection, so that I didn't break the law in the future. So, but I didn't have any interest in publishing contracts anyway. It was just a way of getting a recipient to say that they had received my letter, because they had stopped talking to me at some point, and it was just a manipulative tool for me. So the judgment means nothing, and I thank the judge for that judgment. Now, when you take documents to the court to be filed, you need to be aware that the people behind the desk might yell at you a little bit, especially if you've only got a day turnaround between when you're filing the documents and being heard. I got roused at quite abruptly for not having the documents earlier. That is because that the documents that you hand in are not scanned onto the system. They are actually physically hand typed onto the system. So that means people must sit behind a computer and hand copyright everything that you've written onto the system. It wasn't until I had told the lady that I was only served on Friday, that Thursday afternoon, saw a lawyer on Friday, wrote the documents Saturday, Sunday, got them stamped by JP Monday, and I'm here Monday afternoon getting them put into the system, so to appear tomorrow morning. that she asked who was taking me to court, and when I said that they own a number of satellites, she said, "Oh, you're one of those cases." And I said, "What cases?" She goes, "David and Goliath." And I said, "Yeah, pretty much. They want to put their big foot all over my face." And she said, "Don't worry, we're going to get it on the system." And at which point she called 10 people over to the counter, and she made sure those documents were on that system by tomorrow morning. And I am absolutely humbled by that lady in the court office there who did that for me, and I appreciated everything she did for me after she realised what my case was and who was taking me to court. If you're unsure about documents or what you need to file, you would be better off calling a free lawyer. You can't go to the courthouse and ask the court clerk. They can't tell you one way or another what document you should file, or what you should write on the document, or what evidence you can provide. The court clerk is only there to file the documents, and give you your bill for filing those documents, of course. But you need to do your work outside of the courtroom. You can't go to the court office and ask them to do it. You could probably contact the court's free lawyer. He may be able to give you some advice, but he's going to try and talk you how to represent yourself no matter what, or settle out of court, because a majority of these cases where you're self-represented lose their case, and they lose it because they haven't done their homework prior to walking in the courtroom, or they're guilty, one of the two. So just be aware that when you go to court, the clerks aren't being rude when they don't help you. They're just doing their job. So don't lose your temper with them, because you need them to get those documents on file. So be kind and courteous to them. The court clerks can't give you access to a judge, so you can't go and talk to a judge about your case prior to the case. So forget that. Put that right out of your head. When it comes to the court clerks, they can't tell you whether you filled your documents out right or wrong. They can't tell you whether the information's right or wrong. So check your work before you hand it in, before you get it signed by JP and waste his time. And once you've made your checks and balances, then by all means file your documents. When you're dealing with an opposition, an applicant is coming after you, once they have a legal team, refer all your letters to the legal team. Do not have any direct contact with the actual litigant. So don't contact them for anything. But what you do is contact their legal team a lot more than what you were the litigant. Now, the reason I say this is because every time a lawyer opens a letter, it's $125. Every time they read the letter, it's $150. Every time they reply to a letter, it could be $500. Every time they address a phone call, it's like $25, and then it's $25 a minute thereafter, so it can be $150 for a phone call. So as soon as I knew ISS got a lawyer, they used Emma Lawyers in Melbourne, first thing I did was I started pumping more letters, and I pumped them out chronically every day, for the purpose of building a budget. Now, in the first instance, most people think, oh, just write to them when you need something. Oh, no, don't do that. Write to them as often, as frequently as you can, even if you're just telling them, I fed my cat today and it took two and a half minutes to open a tin. Just send them the letters, because every time they open it, they're racking a bill. Now, most companies and lawyers will come to an agreed term as to how much this litigation is going to cost. Now, being a single guy who's not a lawyer, has no legal background in the courts, has no process of the courts, has never been to court really for anything like this in his life, they may have put 30 to 50,000 on it to say, look, we'll go to court and smash this dude to the ice age, and he'll never show his head again. I reckon I probably spent that in the first 2 months of just writing letters. I racked up their bill like no tomorrow. In fact, I was even quoting laws that were outdated to see what response I would get back, and normally they would write back to me correcting me that the law I was looking at was no longer applicable because of such and such a case, which means I knew then which case to apply to look at, and once I looked at that case, I would apply the meaning of that case to my case, which helped me build my case even stronger. So just because you're shooting high and right doesn't mean you miss your target. I addressed letters in Old English handwriting. Why? Because I was bored. Really, that was the bottom line of it. But they brought that up in court as my mental state, that people don't write letters like this anymore. So why was I writing letters like this? And it confused them. So if you can keep the opposition confused and a bit off tap and thinking that you're a crazy idiot, then that's the way you do it. Once your case gets under the way, you may be required to do a discovery notice on the other side if they give you enough time. In my case, they gave me 4 days, so there was no time. But if you get served within the 2-week notice, then you do have a right to claim for discovery as to see what evidence is available on their side, and failing to you to provide evidence or them to provide evidence, it leaves you in a position where you may not be able to present it in a court of law, unless you're possibly going to use it to refute some evidence that they supply. And you can actually write to the lawyers and request them to answer particular questions in relation to the case, and they can do vice versa to you. When you do this, be sure to only ask one question per page, because the more pages you send, the more money it costs them. So the idea is to rack up a bill so it becomes just out of this country and out of this world, that they want to proceed with their case because it's just costing them too much money. Or it can use the opposite effect like mine did, where they proceed much quicker to try and save money because it's just costing them too much and it's just continuing. So that's one of the avenues you can use, but you have to reply to questions they ask you, and provide them with any documentation they need to refer to. A key point to mention is that if you hear a mention or a court request from the other side, be sure to respond to it straight away. Failing to respond could mean the judge will make a declaration against you and make an order against you purely on what the evidence they provided and the answers you've already given. So no court case, no hearing, nowhere to voice what's going on. So if you ever hear of a motion being put forward, be sure you reply to that immediately. Don't put it off. It's important. Otherwise, you may not get your day in court. Well, that's about it for today. Please like and share this video. Again, I'm not a lawyer, but I did do a case in the Supreme Court that I represented myself and won. This is just my experience, and I hope some of the advice I've given you works. Thank you.